As reflected in this quote, capital punishment is a subject that is arguably one of the most controversial topics in today's society, as it is hard to draw the line between restoring justice and respecting the basic human right to life. Essentially, capital punishment is a severe form of punishment in which individuals are legally executed as a result of committing the most serious crimes. Despite the fact that this raises many moral problems, the concept of state sovereignty therefore becomes a contributing factor which hinders on a person's rights, which are explicitly outlined in the Universal Declaration of Human Rights in 1948. Upon examination, the practice of capital punishment constitutes as a direct violation to the right to life, which is enshrined in Article 3 of the UDHR. Because a person's autonomy becomes limited in this situation, this effectively contradicts the statement which declares everyone has the right to life, liberty, and security of a person. In addition to the right to life, other basic rights which are outlined in Article 5 of the UDHR are also violated. In accordance to the Human Rights Committee, death row is considered to be a form of torture as it subjects the accused to the mental anticipation of death. For example, in the case of Soring v. United Kingdom, the threat of extradition to the USA for death row subjected the accused to the gruesome conditions both physically and psychologically. This is seen to be a clear violation of the article which states no one shall be subjected to torture, inhumane, or degrading treatment. Therefore, this clearly demonstrates the link between capital punishment and how it directly violates the rights set out in the UDHR. Although it is difficult to calculate the official statistics on the total number of executions under the death penalty, the research compiled by Amnesty International has reinforced the global extent of this issue. In 2017, Amnesty recorded at least 2,591 death penalty cases across 53 countries, with 993 of those being considered as official executions in 23 countries. This was a 4% decrease from 2016, which was the year in which global execution reached its highest peak since 1989. However, upon a historical outlook, the horrific extent of capital punishment is also highlighted, as from 2007 to 2017, there has been over 12,567 global executions. The extent of capital punishment is particularly seen in countries like China, Iran, Saudi Arabia, Iraq, and Pakistan, who have been ranked as the global 5 for executionist countries. Given the fact that China's true extent of death penalty cases are hidden through classified state documents, estimates by Amnesty declare that a ballpark figure of over 2,000 people were executed in 2017. Thus, the remaining 84% of the estimated 993 executions took place in the remaining 4 countries, where the most utilized execution methods included beheading, hangings, and lethal injection. Although these statistics do not provide the true extent of this global issue, this further reinforces the severity of capital punishment, especially in countries where international treaties aren't enforced into domestic legislation. Given that capital punishment is globally perceived to be morally wrong, this has led to the emergence of many international instruments. The first international instrument takes the form of a treaty called the International Covenant on Civil and Political Rights 1966. Upon this legal safeguard, Article 6 is the primary mechanism in which deals with capital punishment, as it outlines the specific guidelines for procedural fairness and the types of limitations on whom member states can impose the death penalty on. Therefore, some circumstances in which the death penalty cannot be imposed on is when a fair trial has not been granted, if the crime was not punishable by death at the time it was committed, or if the offender is under the age of 18 or pregnant. The second international instrument that has been put in place also takes the form of a treaty called the American Convention on Human Rights. Upon inspiration from Article 6 of the ICCPR, the American Convention effectively tightens the restriction on the use of the death penalty and explicitly declares that any state who has abolished capital punishment must never reintroduce it again. This means that any state who has ratified this are now bound to international law. As a result, this serves as a mechanism because as more states agree to this treaty, the opportunity of resorting to capital punishment will significantly decrease due to the state's inability to reintroduce the capital punishment. In conjunction to these legal mechanisms, other international instruments also include non-governmental organizations, which include the Death Penalty Information Center, the American Civil Liberties Union, Amnesty International, and the New South Wales Council for Civil Liberties, all in which deal with this violation through their continual lobbying against government policies to highlight the importance of protecting these human rights. Although these NGOs have no role in enforcing human rights law, they still serve as an effective instrument due to their great influence on the general public. To answer the question on whether international law has been effective in dealing with capital punishment can be effectively summed up as no. Essentially, because this issue presents itself as a problem in today's society, this reinforces the ineffective nature of international law as it isn't binding on countries who haven't ratified the ICCPR into their own domestic legislation. This is particularly seen as in Japan, the concept of state sovereignty has allowed them to have autonomous control of their own use of the death penalty and torture. This is particularly seen as on the 11th of June in 1980, the High Court of Tokyo overruled the decision by the lower court and denied a retrial to 82-year-old Aiwa Hakamada. In this case, Hakamada already had spent 4 decades on death row after he was beat by police into confessing guilty. Although this situation heavily breaches the human rights outlined in Articles 3 and 4 of the UDHR, because Japan has not incorporated the ICCPR into its own domestic legislation, this international law isn't effective in protecting human rights. Therefore, this demonstrates that state sovereignty becomes a big barrier when it comes down to protecting human rights. However, upon a more domestic outlook, the effectiveness of the ICCPR is also seen to be quite high for the protection of human rights in Australia. This is seen as the government has ratified both the ICCPR and the International Convention Against Torture by incorporating the second optional protocol into domestic legislation, which now protects individuals against the death penalty. This is seen in the Crimes Legislation Amendment, Torture Prohibition and Death Penalty Abolition Act 2010, which prevents the reintroducing of the death penalty to ensure that no one in Australia will be executed again. However, this was not always the case, as in the past Australia has failed to protect human rights. This is seen in the case of Ronald Ryan, who was found innocent after he had already been subject to execution in 1985. Although this situation demonstrates the ineffective nature of prior legislation, the role of the ICCPR as an international law has significantly contributed to the protection of human rights in Australia. Thus, it can only be drawn that the ICCPR is only effective in states where it is binded into domestic legislation. In attempts to effectively deal with capital punishment in the future, there are many ways about going around this. The first suggestions which can be applied to mitigate this violation is through the use of media. Through the continual lobbying against the unethical nature of capital punishment, this will gradually shame governments and put pressure on them to respond as a result of the communal outrage. Another suggestion towards this violation is through introducing alternative ways of sentencing procedures. As opposed to the verdict of the death penalty, courts can now maximize their resources to facilitate resources to life sentences where prisoners have the chance to be rehabilitated again and gain better respect for their human rights. The last way in which capital punishment can be dealt with is through the concept of mutual assistance. In this process, international governments can ask other governments overseas for assistance in their criminal prosecutions. Because of this, they will be provided with new ways to deal with guilty people, which hopefully prevents them from resorting to the death penalty and therefore preventing the abuse of human rights. Conclusively, capital punishment is seen to be quite controversial as it blurs the line between restoring justice and respecting the right to life. Although there are many mechanisms in place to deal with this issue, the concept of state sovereignty will always pose as an obstructing factor towards the protection of human rights.